All right. Let me call to order the 12th meeting of 2025 of the Rhode Island Ethics Commission. I will note that we have a quorum present. And the first item on the agenda is a motion to approve the minutes of the open session held on July 29, 2025. Is there a motion? So moved. Motion by Commissioner Callahan. Is there a second?
Second.
Second by Commissioner Peterson. Roll call vote. Commissioner Strauss. Aye. Commissioner Callahan. Aye. Mr. Severini. Aye. Commissioner Peterson.
Aye.
Commissioner Ritchie, I so abstain. And the chair votes aye. Director's report is the next item.
Okay, good morning, everyone. Just to go down the list, regarding complaints and investigations, we have let's see, 7, 1, 2, 3, 4, 5, 6. Well, it looks more like 9 total complaints pending. Right
It's
now.
worse as you go.
It does. That's, and it's summertime. It doesn't seem right. But just to go down the list, in the Thorson complaint, I told you I'd probably have an update by this meeting, and I do. As you know, there had been some discovery outstanding in Philadelphia, some depositions that were respondents counsel was trying to take. It turns out that the respondent was able to get affidavits from the 2 witnesses that are in Philadelphia, and because of that is no longer seeking to hold depositions. So that's good. That aspect of discovery is completed. There is still another outstanding subpoena for a local witness that I need to check up on with respondents counsel, but things are moving along there. And so I think that this is a case that it's going to end with an adjudication rather than a formal resolution settlement. Of course, you never know. So I'll be working with respondents counsel in the coming days and weeks to find a date for the adjudication and to kind of go over how that's going to work. So there'll be more updates on that.
Let me just ask you one question about that. The agreement, they would have an affidavit rather than depositions. That's going to hold true through an adjudication as well, correct? In other words, you're not going to have an objection because you're not going to be able to cross-examine those witnesses.
Well, they've indicated that the affidavits are going to be used as prior sworn statements if necessary, probably, you know, when the witnesses are called, just to, if, depending upon what the witnesses say. So they haven't indicated that they're going to use them in lieu of live testimony.
So your expectations, you'll have live testimony on that.
That's the expectation.
Right. I don't want to go any further. I just want to get a sense of that.
Then just kind of going down the list, the Rogers complaint, that's Heidi Weston Rogers. The parties have agreed to an adjudication date of October 21st for that. So we're planning to adjudicate that complaint on that date. Mark your calendars.
Let me ask you about that one. That'll be a regular meeting date?
It is a regular meeting date. We'll keep the rest of the agenda fairly light, and it will mostly be the adjudication.
I think before we get there, it would be helpful for the commissioners to have an idea of how long you think that adjudication will take.
Yeah, so I don't know the answer to that right now.
I don't mean to,
But we will let you know our prosecutors working with respondents counsel to see if they can, and as we do in every case, we always try to see if there are stipulated facts, stipulated exhibits. You know, we're trying to make your day as short as possible also. So if the parties can just agree to half of the facts as stipulated and half of the exhibits is already, you know, ready to go in, then it shortens adjudication. We're working on that.
I'm sure that other members of the commission would like to have an idea how long they would be here that day. That's really what I'm getting at. My second question is, do we have to make a decision that day? Or is it presentation of evidence and we can postpone making a decision?
You don't have to make the decision that day. A lot of, often the decisions are made. So there's the way it would normally work, but there's no magic formula to it. But the way it most frequently works is the parties have their adjudication, which is a trial. It's an administrative trial, just like any other trial, opening statements, prosecution makes her case, defense makes its case, closing arguments. And then at that point, if the commission wishes to, the commission can retire into executive session where no one is present except for the commission and legal counsel for private deliberations. And then a vote can't be made in that executive session. Then once the commission is done having their private deliberations, if that's what you choose to do, then you would come back into open session, maybe that day, and vote for whether there's a violation of the code and if there's the imposition of any penalty. But if you don't have to make the decision that day. Traditionally, it is made on the same day while the evidence is still fresh, but wouldn't have to.
And to what extent do we have to be clear about our findings of fact and conclusions of law?
Well, there will be a written decision, just like in any, with the way that all the cases go now, even with decisions made, dismissals of probable cause, or in those, we have had a couple of cases where in financial disclosure, where there has been an adjudication, and it's the same thing, the commission would vote as to whether there's a violation and what the imposition of the penalty would be. And then the commission has the opportunity to draft its written decision that explains the full basis for why it found the way it found over the next few days and weeks after that.
And then does that decision come back before the commission for approval on a whole, as a whole?
It would traditionally, it gets, the draft is circulated to each commissioner who separately works with legal counsel, your independent legal counsel, not the commission staff, to make comments, and your independent legal counsel would ultimately compile everyone's thoughts and comments into a single draft that would then circulate again to the commissioners. And assuming everyone's in agreement, at that point, it would get signed by the chair.
Just want to make sure we all understand the process.
And what happens if we don't all come to agreement?
We've never issued a dissenting opinion as part of a decision and order. So the majority rules. So traditionally, the way it has worked is if all 9 commissioners are present, as long as a majority votes, let's say a majority votes to find a violation, let's say it's 5-4. Then the decision would track the reasoning of the majority who found finding a violation.
But if a commissioner chose to come forward with his own or her own perspective on it, would that be subject to being included in such a decision if the commission chose to?
It would be up to the commission. There's nothing that prohibits a dissenting message in the decision and order. It just has never happened.
I think I want to suggest to my fellow commissioners that rather than having an informal polling over the decision when it reaches the conclusion, that it come back before us for a vote and approval as a whole, so that it's clear that it's the decision of the commission. I see a lot of decisions that seem to purport to, I don't mean here, purport to be the findings of a zoning board that the zoning board never mentioned. And then there's no approval of the decision, so what is it? So I would urge staff to bring it to us in a final form. Let us put it to a vote as a whole, so that we're all agreeing this is our decision. And that also affords a dissenter the opportunity to prepare and present at that same time the dissent. I think we should recognize that a dissenter would be writing his or her own dissent.
With the assistance of legal counsel if requested.
That would be true, yes, of course. But not staff is what I'm getting at.
Right.
It makes sense.
All right, so that's where I'm coming from. That's why I asked a bunch of questions here.
The other thing is for a commissioner to deliberate and vote, commissioner has to have been present in all of the proceedings.
Right.
During the adjudication,
Right.
the trial. You don't have to have sat on the initial determination hearing or the probable cause hearing.
Yeah, right.
The issue of bringing the decision to the commission for review at a subsequent meeting, is that, do you want to limit that to decisions that follow an adjudication?
Yes.
Okay,
I do. I think our method with the other ones is fine at this point. I think adjudications are different because they go upstairs potential.
Yes.
And findings of fact and conclusions of law and a decision are critical to review, as you well know. And so my concern is that it properly reflect our findings and conclusions of law. Not mine, not Hugo's, not Frank's.
makes a lot of sense.
Now you can go back to your.
Yeah. So, moving down the list, just to give some updates, the Jason Licciardi complaint is still technically pending because the decision hasn't issued, but I expect that decision to issue this Friday, and you know that that's circulated already among the participating members. That matter was dismissed at probable cost at the last meeting. Complaint against Jonathan Pascua, that's under investigation. The complaints against Robert Lombardo are on the agenda today for executive session, so you'll be seeing those today. Complaint against James Durkin is under investigation. There is a new complaint against Jeffrey McCormick that will be initially determined today in executive session. And then finally, as I mentioned at the last meeting, the commission staff did file a financial disclosure complaint against the last person who had filed their 2024 financial disclosure. That's John Boyle Jr., who's the former Tiverton building official. So that complaint has been filed, and these complaints work slightly differently. They don't come to you for initial determination, financial disclosure complaints, but it will come to you for a probable cause hearing if we're unable to reach an informal resolution with that response. So that handles complaints and investigations right now. Moving on to advisory opinions, there are 4 on today's agenda, and we have 6 that are pending right now. So doing pretty well. Done well this summer to work on these opinions. Been able to expedite a couple of opinions, including a couple on today's agenda to assist the petition. In APRA, we've had 4 requests since the last meeting. We completed all of them within 1 business day. 3 of them related to complaints and complaint-related materials, and 1 related to financial disclosure statements. The financial disclosure item in the director's report, I don't have anything, I've already talked about financial disclosure. Don't have a lot with general office administration, other than to note that our next meeting is September 9th, and that will be our rulemaking also. So that's the meeting where we will have a regular agenda, most likely. We may have some advisory opinions. Probably won't have any complaint investigative actions in executive session. Try to keep that light. Most of the meeting will be devoted to a public comment session regarding the 2 proposed amendments to the gift rule that you've been working on. And in advance of that meeting, we will also publish and print any written comments that we have received, and that will be included in your packet. We'll also update it the day of the meeting. Public comment is actually open for the week following the meeting. We have to keep it open for a week following the meeting. So as more comments come in, we'll give them to you. So there won't be a vote at the next meeting as to whether to adopt any of these regulations. It's really just to hear from the people who have an opinion on it. We haven't received much written comment, but I've spoken with people who indicate that there will be. So while we don't have a lot yet, I'm expecting quite a bit. As far as how many people are going to come to the commission meeting to speak, we just don't know. We'll find out.
Last time,
Go ahead. You ask first.
we had a discussion previously about that in terms of notification and advertising. And, again, is there any updates insofar as how we reach out to the public to inform them that we're having a rulemaking session?
Yeah, so we have, see if I can should make notes on this, but I think I remember it all. So we've done everything that is required under the rulemaking procedures and then gone above and beyond that. So we have a notice is on our website. A notice is on the Secretary of State's website. The notice is published here at the Ethics Commission offices. Notice of rulemaking was sent to all 39 cities and towns, to the city and town clerks, asking them to post and give notice for request for comment. Notice was sent to the email addresses of every legislator in the General Assembly, individually. And most notice was also sent to our agenda distribution list, which is a list that we keep of people who have asked us to send them anything that we're doing at the Ethics Commission. And then I think finally, we sent the notice to the email addresses of every person who in 2024 filed their financial disclosure statement online, which is about 4,000. So if you filed your financial disclosure statement online, which I think all of you did, you should have gotten an email from us that included the notice of proposed rulemaking and request for comment. So we've really tried to flood the state with notice and requests for public comment. Of course, it's summertime, so I don't know. And historically, we don't get a lot of comment on our proposed rulemaking. We get it from the usual suspects, which is good government groups, and then from some municipal officials, usually comment. We don't get a lot of comment from statewide officials, from members of the General Assembly. We'll see. Oh, and I forgot, we also got the email address of every registered lobbyist, and we sent the notice to every registered lobbyist in the state of Rhode Island. So I think we covered the field pretty well. And again, almost all of that is above and beyond what is required by the secretaries.
So now my question is, we have to be here for all meetings. But witnesses and other people don't, if we can provide for remote presence as we did the last time. So are you intending to open the public hearing to any remote presenters?
That's my preference. So we will be opening it up to remote viewing like we always do. And once we get through the live witnesses, if the commission has time and inclination, then we will see if people are interested in participating remote. That, at least as of now, that is my intent. Okay. So one of the things we're doing is we're actually changing our agenda to note that while we offer remote viewing of our meetings, we don't guarantee that it will always work. Some of our attorneys attended the Open Government Summit this recently, which the Attorney General puts on. As you know, the Attorney General is in charge of Open Meetings Act issues, and they indicated that that would be the best practice, and that if you don't put that type of disclaimer in your agenda, then there may be an expectation that if the internet goes down, we have to cancel our meeting. So we never want to have to do that. So it's a service we offer, but we don't guarantee that it will work. So far, it has worked every time.
And there's no statutory obligation to do it.
Correct. That's the director's report.
Do you have any questions for Brown? All right, then the next item on the agenda are the advisory opinions. Is there a sign up sheet, please? First item is Mark Schwager with Andrew Tights Esquire.
Good morning, commissioners. Good morning, Attorney Tonight. Good morning, Mr. Schwager. This draft advisory opinion is in the top team binders. Mr. Schwager is the chairperson of the East Greenwich Town Council. He is here today to seek a hardship exception in order to appear before the East Greenwich Historic District Commission. He would like to appear before the East Greenwich Historic District Commission to seek approval of the replacement of 3 windows and a metal door at his personal residence. The commission reviews questions of hardship on a case-by-case basis and reviews several factors, but however, none of those factors are determinative. And the commission can review, take into consideration other factors. Some of the factors are as follows: whether the subject property involved the official's principal residence or principal place of business, whether the official's interest in the property was pre-existing to his public office or was recently acquired, whether the relief sought involved a new commercial venture or an existing business, and whether the matter involved a significant economic impact. I have listed several advisory opinions previously issued on pages 2 and 3 of the draft. They were based on similar facts to the incident matter. Here, Mr. Schwager has been serving on the town council continuously since his election in 2014. Although his purchase of the property did not predate his election to the town council, he purchased the property last August. The matter pertains to his personal residence. He lives there. In addition, he's also lived in the town in his previous residence for 30 years. The matter involves his personal residence and just replacement of 3 inoperable windows and a very old metal door. So based on the petitioner's representations, the applicable provisions of the Code of Ethics and the prior advisory opinions issued, it is the opinion of the staff that the totality of the circumstances here justified the application of the hardship exception, allowing Mr. Schwager to appear before the Historic District Commission. However, in order to avoid any appearance of impropriety, Mr. Schwager shall recuse from any town council's discussions and decision-making relative to the appointment and reappointment of the members of the Historic District Commission until after the election cycle for his town council seat, following the complete resolution of the matter before the Historic District Commission, including any appeals. Notice of recusal shall be filed consistent with the provisions of 3614(6). Additionally, the petitioner shall, prior to appearing or simultaneously with appearing before the Historic District Commission, inform the members of that board that he has received this advisory opinion and that he will be recusing from their appointment or the appointment consistent therewith. Thank you. I'm happy to answer any questions you may have on this time.
Mr. Schrager, Mr. Tights, you've had an opportunity to review this opinion beforehand. Do you have any questions or concerns about the advisory opinion?
Good morning to members of the Ethics Commission for hearing this matter. I've reviewed the draft. I have no concerns, comments, or questions related to the draft opinion.
Members of the commission, anyone have any questions for either Ms. Papa or for Mr.
I
Schrager?
do have a comment. It's just that on the wording. We've just been through a hearing where we've clarified the role of advisory opinions. When you look at the comprehensive, well-written report of the prosecutor on page 3, the utilization of the words like the petitioner must refuse, the petitioner shall, I think it's more appropriate that instead of the mandatory words, it should follow the parameters of what an advisory opinion is. It is the respondent, or excuse me, the petitioner is advised. You know, instead of the mandatory, I think we should utilize language that is more in accordance with the case that's pending promulgation decision-wise.
Let me ask this question then. There's a line in here I just happened to pick up. It says the petitioner must recuse from the town council's discussions and decision making. Are you suggesting that it should say something more akin to it is suggested that the petitioner recuse, or the petitioner should consider whether to recuse?
Right, because I think it's also important for the sake of the precedent value of the advisory opinions, that as we've gone through a more complete analysis of that rule, it's not mandatory that they be followed. And I think that as far as them serving as appropriate precedent in the future, the appropriate language, and I have no problems with prosecutors' utilization of the historic format, but I think we've modernized it, or it's pending modernization, and I think it should be reflected as we go forward.
My concern on that, that's well said, is if we, don't, follow, prosecutors' language, the petitioner may very well say, well, I'm not, I don't have to, I don't want to. That's not the case here. You have to say that, you know, you should not appear, not that you may not appear. Otherwise, you're taking the full import of the prosecutor's opinion and washing it away.
Let me say one thing before we go further. They're not here present as prosecutors. They're here present as staff people giving us advisory opinions. So I want to make sure we understand, because that's a different standard as we went through in that same decision. We recognize that an advisory opinion doesn't have to be followed regardless of what they tell
Well,
us.
that's, okay, but that, again, that's well, that, we recognize that, but again, language speaks loudly, so to speak. So, I mean, the words speak loud. And remove the word shall not, or shall, as the case may be, and leave it open, I think may cause some problems. That's just,
Are there other comments from commission members?
But we're not bound in our decision to follow the strict wording of the staff, although we have high respect for the staff.
And let me now throw in that we've already been through once before the question of whether we should be telling anybody how to avoid the appearance of impropriety, but that's not really our job, as I understand it. So I'm understanding your point. I think when we make a motion here, you can move to amend the.
Well, is that necessary per se? Because the commission is free in its decision to its own wording. We don't have to adopt the wording in the staff's recommendation.
I agree with that, but it has to come to the commission pursuant to some sort of a motion. We can't just sit here and say, well, we're gonna switch word A and word B. We have to have we have to have a motion to approve as presented, or a motion to approve with amendments. I'm gonna call for a motion. Whoever makes the motion, however it's made, will pursue that motion. In the course of considering a motion, you do have a right to offer an amendment. As I understand Robert's rules, the original movement has to agree that you can amend, rather than having a hearing or a vote on his or her motion. But I don't think that we can simply sit here and say, well, we like X word better than Y, without having it done through a formal decision process.
No, I agree. The language should be amended, that amendment should be voted on. And if it's approved by the commission, then the motion would be to approve the advisory opinion as amended.
Could I move to issue an advisory opinion that the applicant can appear as requested in his letter, noting that our advisory opinion is advisory in nature. And if he has any further questions, he should return to the commission to seek further guidance.
that's already there. That's in every case. we always say to them, you can come back, if you have any questions. I just think we're opening up a can of worms here, there's probably a five decisions we made.
Let me stop us here. I believe there's a motion pending from Commissioner Centarini. I believe that motion is, if I understand it, to clarify that the argument or the point that the petitioner must recuse from town council discussions. That the council, no, well, that's part of our law, shall prior to his appearance before the members inform them of his receipt. I mean, so is that the language you're concerned about?
I was concerned about the language on page 3.
Yeah.
I'm,
That's good. We have to go to.
Need a second.
We need a second, but I'm concerned that right now we have not focused on what, I mean, the motion that's been made is to amend.
That's why I spoke up, I wanted to do
I think we understand the motion. I don't think we understand what would be done after we do that. But if we all understand the motion, then I'll ask, is there a second? I'm not hearing a second.
So presently, there's no motion pending. Mr. Tights has asked to say something. We're open at this point. There's no motion pending, so Mr. Tights.
Thank you, Mr. Chairman. I am not familiar with the discussions that you've been having about the nature of advisory opinions. So I'm coming into this cold, but I do have a thought here, which I think might clarify and make it easier for this sort of thing. We're really here for a hardship exemption. And I think there's a difference between a lot of your advisory opinions when someone says, you know, am I allowed to vote on this issue because my husband is a pharmacist or whatever, and that's an advisory thing. We know that there's a conflict of interest here by definition. So we are coming for this hardship exception. So I think that's a little bit different from the other kinds of advisory opinions. You are actually saying, granting us that hardship exemption, yes, you may do this, and then you are imposing conditions as far as part of that granting of the exemption. So, I mean, we don't have any problem with the language the way you have it. I've dealt, that's been in most of our other ones when we've dealt with hardship exemptions for municipal officials. That's what you put in all of them.
So we could almost do one for East Greenwich. Is there a motion to approve and issue the advisory opinion as presented by staff?
So moved.
Motion by Commissioner Ritchie. Is there a seconder?
Second.
Second by Commissioner Callahan. Any further discussion? Roll call vote. Commissioner Strauss.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centarini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Ritchie.
All right,
And the chair votes aye. Thank you very much.
Thank you.
Very much for your comment, Mr. Tights. Yes, might well be helpful.
Okay. Thank you.
The next one I have is Jason Knight.
I guess I just had a question.
Yeah.
On the back end of our agenda, where we could take a couple of minutes to further discuss Commissioner Centerini's.
Yes, I think that would be appropriate to discuss under
Just want to make sure there's an opportunity to do
the
that.
agenda item.
New business or
Yeah, I think we
General
pick it
comments.
up for general comments and new business. So the next one is Jason Knight.
Good morning, everyone. The draft for this petitioner is at tab A in your binders. Welcome, Representative Knight. Petitioner is a member of the State House of Representatives. Initially elected in 2016, he successfully ran for re-election in the 4 consecutive elections that followed. In his private capacity, the petitioner works full-time as a criminal defense attorney in Rhode Island and Massachusetts. Prior to his election to the General Assembly in 2016, The petitioner's name was on a rotating list of qualified attorneys licensed in Rhode Island, available for court appointments to represent indigent clients in the state's criminal courts. The court-appointed list is monitored and maintained by the Administrative Office of State Courts. Payment for services as a court-appointed attorney is issued by the Rhode Island Judiciary. In 2019, the petitioner requested that his name be removed from the court-appointed list. He would now like to reapply to have his name added to the court-appointed list. The Code of Ethics contains both statutory and regulatory revolving door provisions applicable to current and former members of the legislature. Pursuant to Rhode Island General Laws, Section 3614(5)(n) of the Code of Ethics, no state elected official while holding office and for a period of 1 year after leaving state office shall seek or accept employment with any other state agency other than employment which was held at the time of the official's election, except as provided herein. The term employment as used in this section does include service as an independent contractor. Section 5N contains certain exceptions which do not apply here, but does include an exception for employment for which the Ethics Commission determines that authorizing an exception would not create an appearance of impropriety. While Section 5N applies generally to all state elected officials, the code contains a more specific regulatory prohibition that applies only to members of the General Assembly. Originally adopted in 1991 by the Ethics Commission, along with several other regulations aimed at strengthening the Code of Ethics, Regulation 1.5.2 currently reads as follows: no member of the General Assembly shall seek or accept state employment not held at the time of the member's election while serving in the General Assembly and for a period of 1 year after leaving legislative office. And for purposes of this regulation, employment does include services as an independent contractor. Unlike its statutory counterpart, Regulation 1.5.2 does not authorize the Ethics Commission to grant any exceptions to its strict prohibition. The Rhode Island Supreme Court issued a decision in 1993 specifically upholding the constitutionality of both Section 5N and Regulation 1.5.2. That in re advisory from the governor can be found on page 3 of the draft. In the years following that decision, the Ethics Commission has several times applied Section 5N and Regulation 1.5.2 to legislators. The draft cites 3 advisory opinions on page 3 in which legislators were prohibited from engaging in state employment. In contrast, in advisory opinion 2011-25, located at the bottom of page 3 of the draft, the Ethics Commission did allow R.T. Nunes and Sons, Inc., for which a member of the Rhode Island House of Representatives was an employee, officer, and part owner, to continue to provide snow plowing services to the Rhode Island DOT because it qualified as employment held at the time of the petitioner's election to the General Assembly. Notably, Nunes and Sons had provided snow plowing services to RIDOT on a continuing basis for more than 28 years, having initially secured a place on the snowplow list and then renewing its contract each fall to plow the same routes year after year. It was the continuous nature of RIDOT's snowplow list, coupled with Nunes and Sons having remained on it consistently for more than 28 years, which qualified the contract between Nunes and Sons and RIDOT as employment held at the time of the petitioner's election. Here, the petitioner's name was on the court-appointed list prior to his election in 2016. However, in 2019, he requested that his name be removed from the court-appointed list. The petitioner's name was not on the court-appointed list when he was most recently reelected in 2024. Therefore, the general prohibitions of 5N and Regulation 1.5.2 do apply. Unlike Section 5N, which pertains to state elected officials in general, Regulation 1.5.2, which pertains specifically to members of the General Assembly, does not authorize the Ethics Commission to grant any exceptions to its strict prohibition. Accordingly, it is the opinion of staff that the petitioner may not reapply to be included on the list of court-appointed attorneys while serving in the General Assembly and for a period of 1 year after leaving legislative office. I'm happy to answer your questions or to defer to Representative Knight as appropriate.
Representative Knight, you've had an opportunity to read the opinion before you came here,
Yes,
and you've had an opportunity to talk to the council here.
Yes.
Staff. Do you have any questions or concerns about this opinion?
I have a couple comments, but first I just want to say, number one, greetings, and this is my first visit to the Ethics Commission. And glad it's in this kind of light. I hate it. for it to be some other way.
Lucky you.
And I appreciate all the work you do and appreciate the work of the staff in drafting the opinion and unpacking the issues to look at today. And I also am grateful as legislature, I know many of my colleagues are as well, for just having the process, an advisory opinion process, so we know what the rules are and where the boundaries are before someone steps over them. And in this particular case, I recognize the analysis from the staff based on the published opinions and the statute and the regulation. And I think it's sound, but I think the board should consider a couple of issues related to this request. My particular situation is exactly that. I'm a criminal defense lawyer, and I was on the court appointed list when I first got elected for business reasons. I got off in 2019 prior to COVID. And now for business reasons, I'd like to get back on. And I'll tell you, and this is, it's not cited in the opinion, part of that decision is because the judiciary's just raised the rates on court appointed work, and in my own practice, I'm shifting from, I'm just making a couple of adjustments that getting back on the list would be, from a business point of view, advantageous, which is why I asked. But it's important that you know that the rates, if I were to go back on, the rates that are paid are higher now than they used to be. The cases laid out as precedent in the draft opinion are interesting. I think that for many of them, it's simple application of the rules. It's some General Assembly members wanted to go on to do some sort of employment that they didn't have prior to being elected. So those are distinct factually. The snowplow case, actually, when you get into it, read it, is not so much they gave the person had a 28-year long history of contracting with DOT, but in fact, they were a sub to a GC. So the commission ruled that they're not actually doing business with the state, and that's part of the reason why that relationship was allowed to continue. And in the so that's distinct. And in the school committee case, that person was seeking employment within an agency that they directly oversee through the school committee. So there's no attenuation there. And I think that my situation is distinct in that there's attenuation is really the key in terms of is there an appearance of impropriety? Because what I'm asking to do is to go over to the judiciary, basically do a blind application that is either granted or not granted, not even looking at the name, it just has to do with your history in your experience as a defense lawyer, the trials that you've done, the verdict, that sort of thing. The cases are assigned on a rotating list, so you get in front of a judge and somebody, a defendant appears, they have a conflict, the judge will say, give it the next name off the list. And, if you're there, you're there, if you're not, you're not. So there's very little possibility to exercise undue influence in this case. And I also think it's worth saying, all of this is premised on the idea that I was there before, right, got off, and now just trying to look to restore the status quo prior to this 2016. So really, I think on a factual basis, the distance between the agency that would be affected or is involved and the authority of the state official who's subject to the code of ethics is interesting and makes my situation somewhat distinct from all the cases that are in the draft opinion. I would also just say this, and I'm just going to throw it out there as food for thought. If the statute allows you to grant exceptions, if there's not an appearance of impropriety and the regulation doesn't, then the regulation needs to be fixed to match the statute. Because the General Assembly has spoken, and they've spoken that it's okay for you to give you that authority. And somewhere along the line, a policy was drafted or a regulation was drafted for the commission that where commission said we're not going to give ourselves that authority to act. I don't know why that would be, but maybe this is an opportunity to readdress that. So that's my pitch. And once again, I appreciate the opportunity to be heard, and certainly whatever the commission decides, I will abide by it. I'll treat it as a shall.
Just a quick response, I think, on one point, which is we were given authority to adopt our own regulations that have the effective statute. So that last point doesn't quite carry it. But I want to turn to Ms. Radisha to see if she has any responses to what you've raised.
I do. Were this simply section 5N, 3614 5N, I believe that I could be drafted that a petitioner be allowed to go back on the court-appointed list because of the absence of an appearance of propriety, he'd been on it before, et cetera, et cetera. 1.5.2, my hands are tied. And I don't necessarily disagree with it. It's specifically aimed at the General Assembly. There is no exception, including for an appearance of impropriety. And for that reason, I stand by what I wrote, and I believe it's the appropriate interpretation.
Mr. Chairman?
Yes.
When I was reviewing this, I thought back to the many years that I dealt with criminal matters on many occasions with indigent defendants who received services from court appointed attorneys. The obligation to provide an attorney to an indigent defendant who faces potential incrimination arises from United States Supreme Court decisions. The Gideon case, based on the Sixth Amendment, incorporated an obligation on the 14th Amendment to the states to provide an attorney, recognizing that a trial, fair trial, where someone could be deprived of their liberty interest, could best be assisted by a licensed attorney. In Rhode Island, the Public Defender's Office was established to primarily handle cases for indigent clients. At times, there is what's a conflict of interest with the Public Defender's Office because they represent a different client. They may represent a witness that's somehow involved with the case against the instant indigent defendant. So they cannot meet their duty of sole loyalty to the client that a conflict exists with. To handle that type of situation, the General Assembly, through the delegation of authority to the Chief Judge of the Supreme Court, had that person address the issue by creating the indigent attorney program. The funding for that program comes from the judiciary through the administrative offices of the Chief Judge. The Chief Judge, in his regulations, delegated to the Chief Judges of the trial courts how you are to provide, in accordance with the mandates of the United States Supreme Court, the legal counsel. The indigent program was established. An attorney must be licensed, have malpractice insurance, have a certain degree of competence with regard to the defense of the case, whether it be a misdemeanor, felony, or capital offense. You've got to have so much experience under your belt. What you have to apply every 3 years for recertification, I believe, to show your complete competency in doing. The judge, the trial judge, appoints from a rotating list an attorney. Now, an attorney has his sole or her sole duty to the defendant not the source of the funds. This, in my mind, almost is like a prepaid legal program for indigent people. Under a prepaid legal program, a union negotiates that a member of the bargaining unit can get legal services where the fee is paid as a employee benefit. The attorney in that program works for the client, not for the insurance company, just like a doctor doesn't work per se for a patient, or the insurance company. When I read the code of ethics, I don't believe that there is a direct financial benefit if this gentleman were allowed to apply for that program. Why? The benefit goes to the indigent person, just like they were an employee in a bargaining unit that had prepaid legal. His sole duty in how he earns his money is to the client and not the Supreme Court or the United States Supreme Court. So I don't believe that he is providing services per se to the state agency. He is providing services as an attorney to his client, just like a private attorney would be. And he, or any person who's providing indigent services, is still bound by the legal code of ethics. He can't consult with the judge if a judge was nuts enough to say, the budget's being spent too much, plead this case out, don't take it to trial. He can't do that. Nobody has control over his relationship with his client, even though the funding for the service is paid through a state agency. I think this is unique because it's a constitutional mandate. I think it's unique because it's only a pass-through of funds. And I don't particularly see how there's an appearance of impropriety where a person is willing to undertake this service. And I see it somewhat different. I didn't know the rates went up. A lot of times you had to beg from the bench attorneys to take these cases, especially the ones to the Supreme Court, where appellate attorneys tend to get a little higher rate than indigent client cases. Right. You know.
I have a question, mind if I
Yeah.
ask, do you know how many people are on the list right now?
I don't.
Either.
I don't, I know that the judiciary was in a severe crisis, but very recently, which prompted them to put together a committee and raise the rates. And they didn't do it by much. I mean, the federal court appointed rate clocks in, I think these days, something like 178 an hour, which is not tremendous, but it's okay. It used to be in Rhode Island, they were paying $90 for a non-capital felony, and they bumped and then lower for other kinds of cases. They took everything and raised it up to 112. So it's 112 is a common rate for everything. I think even appeals and murder is a little higher.
So I agree with I struggle with this too. I tried to find I just don't see a way around the regulation. That's the problem. If you don't like the regulation, that's a different conversation, but I don't know what to do. I agree with what everything you said, but how do we get around it?
Yeah, if I speak out of order first.
Oh, sorry.
Well, I question whether he's an independent contractor.
I do too with the service.
How's that an independent
He's
contractor?
the judge.
Yeah, I would just say that, employment, the definition of employment, I think we could use here as, who's the employer, who's the employee. The funding is one question, but I think the obligation is to the client. So really the client's the employer in this case, setting aside where the funding comes from. So I think both the specific regulation relative to the General Assembly and the more general provision, we could get around with the definition of the employment language.
Right, that triggers into the question of independent contractor though, and that's what this thing hinges on, by defining that is in fact an independent contractor of the state.
Yeah.
And I just don't see that. I
Yeah,
see he's being paid by the state.
so I get, in the appellate work I do in my private practice, we get paid under EJA, the Equal Access for Justice Act. And that money is the client's money. It is paid for by the government, but it is earmarked for you to pay your attorney with. And so they can't run off and do anything else they want with it, but it is for your attorney, but it comes from the federal government. So in that respect, I mean, I'm not employed by the federal government at all, in fact, I'm suing them. So, I see where you're going with that, and that makes sense to me.
One quick question for my brother. Did you have a rotating list for attorneys? Our court, we had a rotating list, who would be appointed, same with the district court?
There was a rotating list, but it's about disclosure. Sometimes a person could potentially have the opportunity to get out of jail. And you need, rather than, you try to get somebody who is available quick to help the person get out of jail, rather than just our responsibility to put them in jail sometimes. So, there's a rotating list, but if there was an emergency, there seemed to be a practice where, is someone available who could handle this right now?
So Representative, goes to the courthouse and sits there to get the appointments.
Not necessarily.
You know what, the more I think about this, the more I think that it is an independent contractor relationship.
Well, I want to speak to that.
There's no, that, an employment relationships involves, the employer controlling the method and means of the working relationship and dictating hours and, the way the employee works and what the employee works on. And I don't think a lawyer-client relationship is an employment relationship.
Speaking of independent,
Yeah.
speaking of independent contractor, which is the main of the workers' compensation court. That's an interesting point here. Very interesting. It's sort of, takes the onus away in one sense, but it's still being, in this case, Representative Knight will be paid by the same tax dollar that pays his legislative salary. Will be paid by that same tax dollar to pay his, independent, his order appointed, stipend, if you will. Wow, it's really it's independent contracting aspect speaks volumes, and I agree with that. But the other aspect of it,
I have a question.
and we
Yeah,
could,
I'm gonna take it back to
we
Mr.
could,
Bush's
we could change ourselves something here, but it's money, it's money.
We can't change regulation or law right now.
No, right now.
Mr. Callahan has a question.
Mr. Lucius, can you elaborate, if and how there would be a different outcome if in fact Rep. Knight never came off the list?
Oh, absolutely. If he stayed on the list and never came off of it, I'm not sure we'd be here.
So then it also seems like there's language that each, this is a personal sort of opinion here, layperson. The one layperson here today to carry the day for you all. That there is there not some mark in time every moment someone's reelected? So, and I guess so if we are clearing the slate because you must be reelected, you just don't get it for free, right?
Right.
So how, using the snowplow analogy, and well, again, the depth of the snowplow general contractor act, and just to drive the truck, however that works, but the point is that it seems to me that each reelection cycle would start this process over.
Sure. And at the time of the last election, who's not on the list.
Well, that's
It's
my
as
point.
simple as that,
So if
right?
he was on the list.
Then he's never left.
26.
That's an important component, Commissioner. In fact, I was the staff attorney who stood before this commission during COVID and suggested that a school nurse who only left because she was elected to the school committee and wanted to devote her time to that, months later, could not, because of the revolving door, go back to the Wilbur McMahon School and give the shots to the teachers and the staff and the children to prevent them from getting COVID because of the revolving door. And that had an appearance of impropriety loophole that 1.5.2 does not. And the commission said, we cannot overcome the appearance of impropriety with someone who only left her nursing job months ago to be on the school committee to go back and give vaccinations to children and teachers and staff so they don't get COVID. So that's where I'm coming from. And here, a lawyer does represent the client. And as someone who was on the court-appointed list in family court in all 4 counties, making $30 an hour, I had responsibilities to stay on that list. I had to show that I had insurance. I had to take my CLEs. I had to be updated on everything. And my check came from the state, such that it was. And indigent clients do have a right to an attorney. They do not have a right to Mr. Knight as their attorney. They have a right to provide a counsel. So I sincerely, some of these are tougher to write than others. Mr. Knight's a wonderful attorney, was very pleasant. I don't write the rules, but I've become pretty good at interpreting them, and I can't change my opinion. I defer, of course, to your vote.
So tell me how he's an independent contractor, because I don't get it. Who's he an independent contractor of?
State of Rhode Island, who pays him to represent indigent clients in courts.
But he's not. He's being chosen through a list. And he's being paid through the judiciary to represent a client. He's not representing the interests of his contractor. I have a real problem with him being considered an independent contractor when he's appointed to a position by a judge and happens to get paid to represent a third party. I don't get it.
Respectfully, you just said he doesn't represent his contractor.
Correct.
So he has a contractor.
Well, he has somebody who pays him. Let me restate.
Well, I
I
have
just
nothing.
don't.
I'm happy to answer questions, but I have nothing to add.
That's the key that the chairman points out. He's being paid by the state as a representative, being paid by the state as a potential attorney for indigent clients. Someone might say, well, Representative Knight, go back to the legislature and change it. That's not gonna happen. That's not gonna happen. So we could reject the recommendation of the staff council. We could find that there is no conflict here, and now there's a conundrum. You could do that, right? And so that sort of changes changes the language for legislature in and of itself isn't gonna do for so many different reasons. Can we do it? Yes. It's up to us whether or not we're gonna vote that way. Independent contractor, as the chairman points out, that's the issue here. But it's muddied by the source of income, and there it comes.
What you said right now.
The other thing that comes to my mind is it seems to fall within the general parameters of the class exception. You could look at the class, his class, he's a member of a class of attorneys. And he, under the class exception, a person in the General Assembly can vote on an issue if they represent a class and it's all the defined standards and whatever. But I just don't, I don't see as someone said, the appearance of impropriety when you're fulfilling a constitutional mandate. I don't see it.
Just a couple of things. The class exception applies to people acting in their official capacity. And in this case, as an attorney, Representative Knight would not be taking action in his official capacity. It would be in his private capacity.
Yeah, but the appearance of impropriety is him as a member of the General Assembly. Yeah, it's serving as an attorney in the indigent class. I don't see how you keep splitting the baby.
It's a different provision, right? It's the revolving door provision. It's a different section.
But they claim the revolving door as a prohibitive factor in him going back on the list.
Correct. I'm saying is your point. I mean, I'm on board with the independent contractor thing. I think that going back to other exceptions from other parts of, it's not gonna help us get to the resolution we want. It's gonna just.
How about, let me weigh the waters even further. How about a hardship exception? No, I'm just saying the ridiculous, if you wanna look at this, he could say, well, I need this income. I'm being blocked because I'm a legislator, and yet there's a list of it as the Judge Senator points out, that has to be fulfilled. I understand, I'm just saying, it could very well fall with, whether we're gonna do that or not, I don't see it, but it could very well fall within the parameters of a hardship exception.
The hardship exception is there to allow someone to appear before their own board or a board by which they're.
Well, but again, if you're gonna carry out the point where it's the representation of individuals is mandated by the Supreme Court, now you're looking at a whole different spectrum here.
It's tough when someone wants to do something really, really honorable. Such representing indigent clients for much less than you're worth.
I think we could do it, I think we could change it right here.
Doesn't apply, but.
But not the hardship, I said the money.
I wanna ask the legal counsel on this one, because I'm not clear. We vote no on this opinion. We have not provided any sort of safe harbor to Representative Knight, correct?
Correct, but you need 5 affirmative votes to approve the advisory opinion.
And if we don't approve the advisory opinion, are we able to send it back to staff? Say, would you reconsider this matter for a separate advisory opinion?
Yes. Based on the discussions that have taken place today.
And I recognize staff may never be comfortable with it, and that may be a problem going forward. But I also want to ask Representative Knight, if you were to have to wait a little bit for this opinion to get you safe harbor, assuming it gives you a safe harbor, is that okay with your business plan?
Of course.
I want to make sure.
I'm in no rush. I'm just looking to, thinking about what the future is gonna bring for me and with all my various plans. And I was just looking to add a revenue channel. Those things that is easily jumped in and jumped out of, because as you know, even when you're on the list, you can still decline representations. You can accept and decline as needed.
When the staff comes back with the same thing,
Then we have to deal with that.
okay?
And I'm not saying that that's what the vote will be here either. I'm just trying to find out what happens if we do certain things here.
Just to clarify, if staff were instructed to present another opinion, would it not be based on instructions from the commission as to what it should say?
It shouldn't be.
Well, let me just put it this way. We've had a fairly, I thought, relatively clear discussion this morning about the concerns that different commissioners have. Independent contractors certainly being one of them. And I have to believe that somewhere out there could be law on the nature of the relationship with public defenders. And they're paying entities rather than the court they're appearing in front of, or whatever it may be. I mean, you could argue that they're the independent contractor as opposed to the judge who appoints them, but I don't think that judge can control what they do or should control what they do. So if let me try to think what an appropriate motion would be here. I guess the first motion has to be whether to issue and approve the advisory opinion as presented by the staff. Is there such a motion?
To approve.
To approve.
There is no motion before the commission to approve this advisory opinion. Is there a motion to request to reject the opinion?
So moved.
Motion to reject the opinion, is there a second?
Second.
Because you
Second
have
by
to reject
Commissioner.
the opinion,
In other words, to send it back for,
well, you have to, fair counsel.
well, actually, I think that.
I think there being no second to the motion to approve, the next appropriate motion would be a motion to reject the advisory opinion. as presented by the
To
staff.
reject it for the purpose of.
And then the
Start
next
with the
motion,
next
the
motion.
next motion could
Well,
be,
okay, so the intermediate step, all right.
So we have a motion to reject. I think we have a second on that motion from Commissioner Callahan. So I'll find my sheet. On this motion, a roll call vote. Commissioner Strauss.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Ritchie. And the chair votes aye. Is there a motion to request request staff to prepare, try to prepare an alternate opinion to be presented to us at a later hearing of the commission?
I would like to make a motion to do that, specifically focusing on what is an independent contractor in the state of Rhode Island. Just to start with some federal district court cases that have that definition. The 2020 case that might be helpful. Thank you.
Can I just comment on that? You repeat that motion for that?
A motion to review and reissue an advisory opinion specifically focusing on what is an independent contractor in Rhode Island. That's what this,
Or whether this relationship
Correct.
constitutes an independent contract?
correct.
Is there a second to that motion? Second. Second by Commissioner Centerini. Further discussion? A roll call vote.
I do.
Further discussion.
We wanna ask, staff, or to review the specific statute regarding legislators and how that affects.
That's not part of the
That's not my
motion.
Well, I'm saying I want to add to that, so I want to amend the motion, because I think she's gonna come back with that blockage again.
I think
I think that would more appropriately be a separate motion.
A separate motion.
Yeah,
Okay,
if you wanted to pursue that, yes.
Well, I could ask my sister to add that to her motion, otherwise I could do
you
it.
can move to amend,
Right,
but the proponent of the motion, the movement, has to agree
exactly,
that the amendment be included in the motion that was proposed.
exactly.
I'm sorry, repeat your amendment. I didn't quite follow.
To take into consideration, the legislative, the statute that specifically prohibits members of the legislature, in this particular situation.
Just to consider it.
As part of the alternate
Right,
or
as
new.
far as
I mean, I think they did in the original advisory.
That's the whole thing.
Just by way of reminder, it went before the Supreme Court in 1993, and the constitutionality was upheld,
Yeah.
both that statute and
We have to.
Regulation.
For the same thing.
But that brings us back. to
I'm
independent.
not gonna add that to my motion, but you're free to add
Well,
that.
I'm not gonna add it either, I mean, they gotta come back with.
So the motion before the court, I wish, the motion before the commission is Commissioner Peterson's motion. It's been seconded by Commissioner Callahan. I asked for further discussion.
On discussion, it would be helpful, at least for my clarity of thinking, which gets confused, I'm sure the commissioners recognize it. That what wasn't addressed in the proposed, the report of staff is a more detailed understanding of indigent, the indigent program. What is the role of an attorney? I think you're addressing that as, under the independent. And I would like some guidance on all of that, as what comes forward, just not what is an independent contractor, with all due respect.
Well, I think the motion is, does this relationship constitute an independent contractor relationship, which probably of necessity would require some analysis.
Thank you.
if I can again ask my sister, based upon that, notwithstanding the statute. With that language in?
I mean, if he's not an independent contractor, none of it's, we're all set. Not the statute and the regulation don't apply.
So, and I think your motion was to focus on, but that
Correct.
doesn't mean that's all it has to discuss.
Correct. It still has to be a full, robust advisory
Right.
opinion. I have every confidence that we will get that.
You're not concerned about the fact that the statute is in existence,
No, I'm not concerned about the statute.
I think that's the whole.
Or the regulation.
Okay,
That's the whole point.
So I have a motion and a second. We've had additional discussion. I will call the motion. Roll call vote, Commissioner Strauss.
Aye.
Commissioner Callahan.
Aye.
Commissioner Celerini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Ritchie.
all right.
The chair votes aye. This is a comment to council, to staff council. This has been a broad discussion. Please do as you think is necessary based on what you've heard, because it still has to come back before us, and I want you to feel you have the independence based on what you've heard here, to put it all together as you see appropriate. We don't want to tell you how to do your job.
Certainly not.
Well,
I
Thank you.
think that.
Thank you very
And
much.
Representative Knight, we obviously will be back in touch with you. We do appreciate you coming in. We do appreciate the nature of the conversation, and we appreciate your service.
Thank you very much. Thank you for everything you guys do. Great day.
The next on the agenda is the advisory opinion for Samantha Contreras.
Yes. This draft is at tab B, as in boy in the binders. Okay. Welcome, Ms. Contreras. The petitioner is employed full-time as an interpreter for the Rhode Island Supreme Court, a position she has held since September of 2022. Her hours are Monday through Friday, 8:30 a.m. to 4:30 p.m. She interprets only for the Rhode Island Supreme Court and not for any other state courts. In her private capacity, Ms. Contreras is the sole owner and lead interpreter for SC Interpreting and Translation Services, LLC. She started the business in March of this year, although she currently has no employees or clients. Eventually, she would like to contract with as many different interpreters as possible, including those who can translate English, Spanish, Portuguese, Cape Verdean, Haitian, and Chinese. She does not currently maintain a list of interpreters and has yet to advertise for them. Eventually, the petitioner would like to use the interpreters with whom she contracts to provide interpreting and/or translation services to, among others, Rhode Island state agencies, excluding the judiciary in its entirety, and to non-state agencies such as municipal school departments, private hospitals, and healthcare providers. Ms. Contreras would like to register her business as a vendor on the state's master price agreement list through the DOA's Division of Purchases. State agencies order their goods and services from the relevant MPAs as their needs arise. State law permits quasi-state agencies, municipalities, and school districts to also use the MPA vendor pool. Now, there's no guarantee that any vendor will be issued a contract for services. The petitioner has sought and received permission from her state supervisor to engage in the proposed secondary employment, and now seeks the opinion of the Ethics Commission regarding same. The Ethics Commission has consistently opined that public employees are not inherently prohibited from holding other employment that is secondary to their primary public positions, provided that that other employment would neither impair their independence of judgment nor create an interest in substantial conflict with their public duties and subject to certain other restrictions. Petitioner states that engaging in her private business would not impair her independence of judgment, which is consistent with the staff's analysis of the facts as represented. There are several additional factors that are analyzed when considering potential conflicts regarding secondary employment. They include, but are not limited to, the following. First, we have the nexus between the public official's public duties and their proposed other employment. Here, other than the similar skill set involved for each, there appears to be no relationship between the petitioner's public duties as an interpreter for the Supreme Court and her intended work as the owner and operator of an interpreting and language translation business. Next, whether the employee completes such other work outside of their regular working hours without the use of public resources. Importantly, Ms. Contreras states that she would complete her private work outside of her regular working hours for the state and without the use of public resources. Next is whether the employee is required to appear before their own agency as part of their other employment. Petitioner further states that she would not be required to, nor would she ever appear before the Supreme Court as part of her other employment. Then we have whether the other work is to be conducted outside of areas over which the state employee has decision-making jurisdiction. Petitioner's other work would not be something over which she would have decision-making jurisdiction in her capacity as a state employee. And finally, whether the employee uses their public position to solicit business or customers for their secondary position. Ms. Contreras states that she would not do this, nor would she solicit her Supreme Court colleagues to contract with her to perform interpreting language services for her private business. The draft includes 2 examples of advisory opinions, both issued in 2019, applying these factors and ultimately allowing the desired secondary employment of the 2 state employees. Based upon the petitioner's representations, a review of the applicable provisions of the code and consistent with prior advisory opinions issued, it is the opinion of staff petitioner is not prohibited from registering her private business as a vendor for the state of Rhode Island in order to provide the language services described in the draft. Of course, this advisory opinion can't anticipate every possible situation in which a conflict of interest might arise, and thus provides guidance as to the application of the code based on these particular facts. Running a business where calls could come in at any time of the day and potentially with short notice of the need for an interpreter could become tricky, so though certainly not impossible to navigate. The petitioner is advised to remain vigilant about adhering to this advisory opinion if it's approved, and to seek further guidance from the Ethics Commission in the future as warranted. I'm happy to answer your questions or to defer to Ms. Contreras.
Ms. Contreras, you've had an opportunity to review the advisory opinion before you came.
Yes,
Do you have any questions, concerns, comments about the advisory opinion as drafted?
I do not.
Any questions of the commission to either Ms. Rodriguez or Ms. Contreras?
Good morning. I am curious in terms of your current state employment, with the Supreme Court, is there a thread where you could, outside of your own decision-making, be moved to another position within the state government or, the different court system based on your seniority or based on the need of the courts or based on, some type of an external stimulus that they said, you know what? We really need this expertise over here, and so we're gonna move. Is that possible?
That is not possible.
It's not possible. Is that based on union representation, or why is it not possible?
More like as an interpreter, that's basically where I am and that's basically all I do. In each court, so there's nowhere else that I can be, or no other position I can have. As an interpreter.
Right. Just the Supreme Court though, is that?
Supreme Superior District, that's that one.
Okay.
It's all the trial courts.
Well, okay.
There's one court that she needs to be in is a worker compensation. That's where we need interpreters. So, I mean, that's, you never.
I have worked in, yeah, we do, we have a rotation for the
Yeah,
workers' comp.
you do, sure. So, with your SC,
Interpreting insurance.
yeah, I mean, the employees within the SC could be assigned, not assigned, they could,
We would exclude the judiciary
the
altogether.
entire judiciary.
Yes.
Okay.
I know that would benefit you and workers.
No, I know, yeah, I know, and I'm just saying, see, it's like you're an interpreter for the Supreme Court, doesn't say that you're an interpreter for all the courts.
Well, the Supreme Court is
the umbrella.
It is
So-
the umbrella,
so
right.
we cover all of the court as interpreters for the Supreme Court. We
I
have a
apologize
rotation.
for my misunderstanding then, because I understood it to be limited to Supreme Court.
Thank you.
It's hired by the Supreme Court in an umbrella, all the interpreters.
I thought there might have been a specific situation for her, that regard, okay? Well,
Not clear. Okay. My, I guess for Mr. Vicious, is there a thread where the respondent as a, petitioner, pardon me, as a principal of an organization has a responsibility for, let's say that your business does grow, it's robust and it does all the things that we want it to do for you. But they themselves are within the domain of state employment, and so is that an individual person's requirement, who could theoretically work for Ms. Contreras? Is it their individual responsibility to get an ethics opinion about how they go about their job if they're within state employment? Is that making sense? And my point is that if there are, does the principal have a higher, the principal of a business have a higher threshold or a higher requirement for the ethics of the organization as it permeates?
If I understand you correctly, no. In other words, if another state employee wanted to go work for Ms. Contreras' private business,
That'd be
that
their-
person would need an advisory opinion as well.
Okay.
Presumably, most, if not all of her employees will not be state employees. She's certainly not going to solicit them from her colleagues at work. I would ask, I do have one sentence in the first full paragraph of the facts. The last sentence states, she further states that she does not provide interpreting services for any other state courts in Rhode Island. I don't know if that needs to be edited.
I don't provide, services for traffic tribunal or the municipal.
Would it be more clear, would it be more truthful to say she states that she does provide interpreting services for other states? Just to take out the not. Because I really heard it the wrong way, I misunderstood.
well, the Supreme Court doesn't recognize the traffic tribunal, not traffic, the municipal courts being part of the judiciary, so let's get that clear. Traffic tribunal is part of the judiciary.
Ms. Radicious, where are you in the advisory?
The last sentence of the first full paragraph of the facts that starts the petitioner is employed full-time. I would suggest taking the last sentence in that paragraph from, she further states that she does not provide interpreting services for any other state courts in Rhode Island, to, she further states that she occasionally provides interpreting services for other state courts in Rhode Island. Or something to the effect of the Supreme Court, her employment at the Supreme Court encompasses work for the other state courts.
Well, municipal and probate courts.
The state, they're not state.
No,
courts.
not, that was, just that language, municipal and probate courts. That's the only other courts we have besides.
I have a suggestion.
Yeah,
tonight.
please.
In that same paragraph, if you just change the first sentence to note that she's employed by the Supreme Court as an interpreter for the judiciary, and then deleted the final sentence.
Okay.
That would seem to cover everything.
Any other questions or comments? Do I hear them? Well, is there a motion to approve and issue the advisory opinion as presented by staff with the slight editing that, Executive Director Grammett has proposed for here as amended and presented by the staff? Moved by Commissioner Ritchie. Is there a second? Second, Commissioner Centerini. Any further discussion? Hearing none. Roll call vote, Commissioner Strauss,
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Peterson,
Aye.
Commissioner Ritchie, and the chair votes aye. Thank you for coming in.
Thank you so much. I appreciate your time. Good.
Yeah. The next item on the agenda is the question of the town council. Town of New Shore, I'm going to confirm that. How it's stated. The town of New Shore on town council by and through its solicitors asking for advisory opinion.
As to this matter, before it begins, We have some people who are going to join us remotely from New Shoreham. There are 3 impacted town council members who were invited to join, along with the town solicitor, Nick Solitro. Solicitor Solitro is here, and I'm going to bring him into the meeting. I don't think that any of the other council members are present. There is someone who appears as an anonymous member in the audience, and I would just state that if any of the affected town council members are in the audience right now and would like to come into the meeting, that they raise their hand or change their name so that it reflects who they actually are. Raise your hand, I'll bring you in. And at this time, I'll bring Solicitor Solitro in, and he may be able to advise us whether any of the town council members were invited.
I can say that Mr. Payne was the only town council member who indicated that he would be attending. Ms. O'Neill has work obligations. She was going to do her best, but if she wasn't here, I wouldn't be surprised. And I did not hear from Mr. McComb as to whether he would be using the link today.
Good morning, everybody. Nicholas Solitro for the town.
Good morning.
Podium is yours, Ms. Felicius.
Thank you. Good morning, Mr. Solitro. Nice to meet you.
Good morning, nice to meet you.
All right, the New Shoreham Town Council is unable to achieve a quorum relative to a pending matter. The matter involves a proposed ordinance that would regulate the operation of courtesy shuttles by local businesses on Block Island. The inability to achieve a quorum is the result of 3 of the 5 town council members recusing due to a conflict of interest. In situations such as these, the Ethics Commission may employ the rule of necessity by determining who among those citing conflicts is the least conflicted, and then allowing that person to participate so as not to render, in this case, the town council unable to act. Importantly, the rule of necessity is only used to achieve a quorum when the absence of a quorum is due to multiple recusals due to conflicts of interest. Were a quorum to be lacking due to absence, illness, vacation, or the like, the rule of necessity would not be used. As to the proposed ordinance before the town council, earlier this year, the town council received a letter from 2 New Shoreham residents who own and operate taxi businesses on the island. Enclosed with the letter was a proposed ordinance for consideration by the town council, which would regulate the provision of courtesy shuttles by local businesses to their patrons. The increased use of courtesy shuttles over the past several years has become contentious, as it may be taking business away from taxi and bus drivers. There are currently approximately 34 active taxi licenses on Block Island. There is an extensive wait list where people will wait years for an opportunity to apply to obtain a taxi license. There are 2 active bus licenses on the island. There are reportedly at least 10 shuttles currently operating on the island, some of which travel from an owner's place of business to a set drop-off location, and others which travel from the owner's place of business to locations as requested by the patrons of those businesses. The following 3 town council members recused from participation in consideration of the proposed ordinance. First, Tristan Payne. Mr. Payne is the sole employee of a helicopter tour business which offers free courtesy shuttle to its patrons. Mr. Payne not only pilots the helicopter, but he operates the courtesy shuttle to transport the patrons between the ferry landing and the airport. He has held his employment for 10 years. He's transported the patrons for the past 7 years to make sure that they have timely arrivals in order to adhere to a strict tour schedule. Mr. Payne is not paid extra by his employer for these transports, and he accepts no gratuities from patrons for them. He does, however, accept gratuities for the actual helicopter tours. Mr. Payne's mother is one of the 2 taxi drivers who sent the letter to the town council requesting consideration of the proposed ordinance. She's a farmer on Block Island, and she's also driven a taxi there for 50 years. Mr. Payne states that without the regulation of courtesy shuttles on the island, his mother and other similarly situated taxi drivers will have fewer opportunities to transport people, which will impact their income. Mr. Payne acknowledges his conflict of interest under the circumstances. Next, we have Ms. O'Neill. Ms. O'Neill's spouse has held a taxi license on Block Island for the last 14 years, which he uses to derive an income. He's employed full-time as a carpenter, but drives a taxi a couple of days each week during the summer months. He also employs 3 other drivers who work most days and evenings. Ms. O'Neill acknowledges that because taxi license holders will be directly financially impacted by the regulation of courtesy shuttles through an ordinance drafted and passed by the town council, she is required to recuse from participation in the matter. Finally, we have Mr. William McComb. Mr. McComb holds one of the 2 bus licenses issued by the town. He's employed by the Block Island Ferry. Mr. McComb allows his employer to utilize his license at no charge to offer and conduct bus tours and transport wedding parties and guests numbering 20 to 49 people at a time. On those occasions where Mr. McComb himself operates the bus, he receives no additional compensation from his employer. Mr. McComb's employer does reimburse him for the cost of his license and any additional fees associated therewith. Mr. McComb opines that an ordinance addressing courtesy vehicles would likely have no financial impact upon him or his employer because the bus used by the Block Island Ferry does not operate as a taxi. Because the proposed ordinance regulating courtesy shuttles on the island has yet to be considered and potentially amended or rewritten by the town council, it's unclear at this time whether and to what extent the employers, the family members, and even these 3 town council members themselves could be impacted. For this reason, it appears that 3 of the 5 town council members have each properly recused at this time, and it's appropriate for the Ethics Commission to apply the rule of necessity. Under the rule of necessity, the 2 town council members who have not asserted a conflict are required to participate. Here, the remaining official determined by the Ethics Commission to have the least conflict will be permitted, to participate. Mr. Payne's employer would be directly financially impacted by an ordinance regulating courtesy shuttles. Also, Mr. Payne's mother is one of the 2 taxi drivers who submitted the letter and proposed ordinance to the town council for consideration. For these reasons, it is the opinion of staff that Mr. Payne should remain disqualified from this particular matter. In staff's opinion, Ms. O'Neill should also recuse, given that her spouse holds one of approximately 34 taxi licenses issued by the town from which she derives an income. It is the opinion of staff that here Mr. McComb is currently the least conflicted because as the owner of a bus license that is used by his employer to transport groups of 20 to 49 people at a time, neither he nor his employer would appear at this time to stand to be personally financially impacted by an ordinance regulating courtesy shuttles in the manner that a taxi operator would. However, a conflict for Mr. McComb cannot be ruled out completely because it remains to be seen whether and how an ordinance regulating courtesy shuttles in New Shoreham would directly financially impact the owners and or operators of buses under the 2 bus licenses issued. Accordingly, in order that the town council may conduct its statutorily assigned duties, the staff's recommendation is that Mr. McComb should be permitted to participate and prior to his participation in that matter, file a conflict of interest statement consistent with the provisions of section 3614(6). He should disclose his interest in the matter and affirm that despite that interest, he's willing and able to participate fairly, objectively, and in the public interest. Mr. Payne and Ms. O'Neill should recuse from participation in voting on the matter consistent with the provisions of section 3614(6). I'm happy to answer your question.
Thank you. Mr. Solitro, you're here representing the interests of the members of the town council, correct?
Yes, sir.
And you've heard Ms. Radish's report? Yes.
I have, yes.
And you've had an opportunity to review it?
Yes.
Do you have any questions or comments concerning her report?
I don't, and I do want to commend her for a very thorough report, very professional investigation, speaking to my town council folks. She did a great job. The town had no dog in this fight. We weren't advocating one way or the other as to who may exercise the rule of necessity. We were simply seeking guidance. And I think the report does just that and does an excellent job in what it does.
Thank you. Members of the commission have questions or comments?
Just a quick question for Mr. Decius. When you are articulating Mr. McComb's relationship with his employer, is it his personal bus license? Or is it and is he executing his duties with that license for his employer? Or could he take it? Let's assume that he was like, yeah, I've had enough and I'm gonna go do something else.
I believe the license is his personally, and he allows his employer to use it.
How does that work?
Yeah.
Respectfully, that would be between him and his employer. I did not get into that for these purposes.
Still comes down to the fact that he's neither a taxi driver nor a courtesy shuttle driver.
That's correct.
And the other two have enough contact to one or the other that they are more conflicted than he may be.
Yes.
Could I,
Commissioner Center,
just for my educational purposes, because what's the authority for the evaluation of the different levels of conflict of interest as it affects who can vote and who cannot vote under the rule of necessity? Because what crosses my mind after many years in municipal government was that each of these council people represent certain residents, constituents who voted them in, you know, respecting the right of people to vote. I mean, an analogy of the street, and I apologize in advance, probably because it's an inappropriate comment, but you're not a little bit pregnant. If you got a conflict, you got a conflict. And why should some constituents be denied on a level of a conflict while others are not? I just, what's the authority?
Sure. Well, that reminds me, what you said, Commissioner, reminds me of the times when, let's just say, someone from the planning board in another town has a conflict and says to me, you know, I was elected to do this. I know it's gonna involve my personal business, but the voters have spoken and I'm the one. That doesn't mean that there's no conflict. In this case, when you can't reach a quorum because so many people have conflicts, the reason the rule of necessity came about is because we can't shut down the town council and keep them from doing something because 3 people are conflicted. My understanding is, years ago, this would have been decided by literally flipping a coin. Someone's got to take part. Okay, who's got heads? It's you. Now we try to find the least conflicted.
What is the legal authority for that?
Mr. Grammett wants to comment on that, I think.
Yeah, and Mr. Redicius is right. There was a point where the commission just drew by law and to decide which of the 3 would be the one. And the commission decided that was not the better way to do it, that the better way to do it would, and I'll get to the authority issue, but that the better way is to determine who has the least amount of conflict and to allow that person to come in, and who better than the commission to decide who has the least amount of conflict than the commission, the people who deal with it every day. As far as the authority goes, my understanding is the basis of the authority is that the commission has the ability to offer people safe harbor through the advisory opinion process. And so to the extent that the commission chooses to offer safe harbor to one of these 3 people, it's certainly within its authority to do so through the advisory opinion process. And it's using the rule of necessity to do that. Offer safe harbor just to one of the 3 based on a determination of who has more of a conflict.
So I think maybe following up on Commissioner Centerini's question, there is no specific authority for us to take on rule of necessity problems.
There's nothing in the code that references rule of necessity, but certainly the rule of necessity has been used by the judiciary, of course. I'm sure Judge Centerini is aware of that. And also, there was I believe, although it was about 25 years ago, the commission had to go to the Attorney General to apply the rule of necessity to the commission to determine which commissioners could participate in a complaint matter that involves Speaker of the House. And so the rule of necessity has been applied by the Ethics Commission. It has been applied to the Ethics Commission by the Attorney General. So that's a part of what we're concerned.
The Supreme Court spoke of the rule of practicality in many cases.
And the rule of necessity is a common law standard that applies to any body or board or judicial issue where there's a sufficient conflict that there would not be a quorum otherwise. And I think the point here is that sole only thing we are voting on is how do they fill their quorum? We're not being asked anything about the ordinance. We're not being asked anything about the merits. We're only being asked to pick, to help them pick the ones who will break the problem of no quorum. It has no impact on any of them in terms of their financial result. It's a purely administrative question, I believe.
It just seems to me that that offering safe harbor to one and not potentially all. I mean, to me, to me, there's some due process there. I don't know. That's
I think that, I think.
Safe harbor is that's an important concept, the legal protection. I mean, I don't know.
Well, all I'm gonna say is the rule of necessity says appoint members necessary to complete the quorum, not to allow others who would otherwise be conflicted or have reasons not to sit as well. And I think the question of, you were voted in, well, all elected officials are voted in. So if we took the position that, well, you were elected by your constituents, so you should be able to vote, that takes us to take the tables, put them in the other room and go away, right? Because any elected official would say that.
I only make that suggestion based upon you got three, you're only picking one. I mean, that's that's due process. I don't know.
We only need one to make a quorum.
That's
I
right.
think if we need two to make the quorum, then we vote on two.
Two.
If we need all three to meet the quorum, then we could give them all safe harbor.
Right.
But we're doing the narrowest possible exception. I agree with the analysis because I think that the person who identified barely even has a conflict. I don't even know if they have a conflict, so I think that makes sense.
Only if they define a shuttle as carrying
Right.
more than 28
Right.
passengers or whatever. So. Any other question or comment by the commissioner members? Mr. Sleeper, you've heard the comments. Do you have anything else to add?
I don't. I just, again, appreciate the thought that goes into this. This is similar to Mr. Knight. I've been practicing law, not as long as him, but for a bit. This is my first trip to the Ethics Commission. Glad to be on this side of it and see how the sausage is made. It's impressive. I appreciate all the thought that goes into this.
Mr. Speaker, can I ask you a question, please?
Sure.
34 taxi licenses authorized or issued, which?
I believe both. It's New Shore issued.
New Shore had 34 taxis, sure.
I believe so, and they're a hot commodity out there. New Shoreham is unique in that their taxi licenses are not regulated by the state of Rhode Island. The General Assembly allows the town to regulate them themselves. So it's quite the industry out there for folks, whether it's their sole source of income or supplemental income. It's quite the commodity to have a taxi license.
Yeah.
If I'm not mistaken, there might be more than one driver per license allowed. That was my understanding.
That's my understanding as well. You may hold a license. It may be up to 4 drivers that you can authorize on your license.
34,000 insurance.
Any other questions, comments? Is there a motion to approve and issue the advisory opinion as presented by the staff?
So,
Motion by Commissioner Ritchie. Is there a second?
Second.
By Commissioner Callahan first. Second by Commissioner Callahan. A roll call. A roll call vote, Commissioner Strauss.
Aye.
Mr. Callahan, Mr. Centerini.
Aye.
Mr. Peterson,
Aye.
Mr. Ritchie,
Aye.
and the chair votes aye. Thank you, Mr. Solitro.
Thank you all. Have a nice day.
He beat him. That's what I'm saying.
No, this week.
All right, next.
If there's a moment you want to restroom break.
So,
I just go on.
Yeah.
Every year, whenever that.
so the next item on the agenda is a motion to go into executive session, to wit, a motion to approve the minutes of the executive session held on July 29, 2025, pursuant to RI General Law, section 4246, 5A, 2 and 4. In re Robert L. Lombardo, complaint numbers 2025-3 and 2025-5, pursuant to RI General Law, section 42-46-5A, 2 and 4. In re Jeffrey McCormick, complaint number 2025-6, pursuant to RI General Law, section 42-46-5A, 2 and 4. And a motion to return to open session. Is there a motion to go into executive session?
Someone,
Motion by Commissioner Callahan, is there a second by Commissioner Peterson, Commissioner Strauss,
Aye.
Mr. Callahan, Mr. Centerini.
Aye.
Mr. Peterson,
Aye.
Mr. Ritchie,
abstain.
and the chair votes aye, and we will take a 5-minute break at this point, or as needed.
If there anything else, then, since I wasn't at the last, oh, I'm sorry.
I just don't want, I'm gonna get off record first for this one.
So,